Your takeaway from the indictments, I assume you've had a chance to kind of at least roughly comb through it a little bit. You know, to Daniel Alonso's point, a lot of the information that we were getting over the past couple of days was narrowly, I don't want to say leaked, but was from the Trump Organization attorneys that was being shared with reporters. I can't say definitively that most of the information was coming from the district attorney's office, which has been pretty tight-lipped. But now that we've actually seen the indictment, that it has been unsealed, it's 15 counts, it spans nearly 15 years, I guess, of alleged wrongdoing. What do you make of the scope of the indictment now that we've seen it?
I pay a lot more attention to the 15 years than the 15 counts, which effectively charge the same conduct in different ways. But basically, Ron Fischetti was more or less accurate, but as a good defense lawyer, he spun it in the favor of his client. I have sort of two different views of this. First of all, as to the crimes alleged in the indictment, the evidence seems to be very strong. They have spreadsheets, clearly. They have the tax returns. They have Weisselberg's tax returns. They have signed leases from the Trump Corporation itself. It is very powerful evidence in support of this scheme. I think the real question, though, is looking at this from a 30,000-foot view, not the very fine point view that we as lawyers will look at, is this a serious set of charges? Now, of course, it is serious. As Dan said, it is a tax fraud scheme. But it is not the type of crime that I think there's been a lot of rumbling about, where the Trump Organization itself was defrauding insurance companies, was defrauding tax authorities by misvaluing their properties, was defrauding banks by misstating their assets in order to get loans. Those are a type of crime of a different nature. This really had to do with breaking the law, but it was skirting the tax laws for the benefit of their employees, essentially so they could pay fewer taxes and giving the same compensation. Again, it's serious. Yeah. I'm not questioning that. And the evidence is very strong of that. But I do think there's some credence to the notion that this is not usually charged against corporations. It's charged against individuals a lot. But it is not the type of crime that is usually charged against corporations. On the flip side, 15 years and what is a sophisticated scheme to do this is the type of persistent and pervasive conduct that is considered when charging a corporation. So it's not that it's unjust or unmerited or unwarranted. It's just that it is not as serious as the types of crimes that even the Manhattan DA's office has said they were investigating.
So to that point, Mr. Alonso, do you think that we are at this point today because of a miscalculation by the district attorney's office? Could they perhaps wanted to get more information about the organization or perhaps even higher ups in the organization? And it came to this point, as some earlier have suggested, legal experts have suggested, that in an attempt to get the cooperation of somebody like a Mr. Weisselberg, that they would threaten him with prosecuting his own wrongdoings and that of the organization. And ultimately, he called their bluff out, and they either had to walk away from it or proceed with what we're seeing today. And that's why we are where we are.
I don't think this is it. I do agree with Dan, obviously, that these are not of the level of seriousness of some of the things we've heard they're investigating. But they also, as I understand it, I wasn't in court, but they said on the record that their investigation is very much continuing. They even asked for a protective order for discovery. So I do think that they are very much continuing. They've got another, I think, 5 months left in their special grand jury. So there's every indication that the reason they brought these charges now is, I'd say, 1.5-fold. One is because they're calling Alan Weisselberg's bluff. They wanted him to cooperate. He said no. And instead of saying, OK, we'll call you in 5 months and slap the cuffs on, they did it right away. And the other, the kind of half, is there are other executives that appear to be part of this. And if the indictment is to be believed and taken at face value, as I do, then those people are likely just as guilty as Alan Weisselberg. Maybe it's not as much money, but they are just as guilty, and they are also themselves potential people who could cooperate. And since their names, I don't know if their names have surfaced yet. Obviously, some people's names have popped up, but it could be that they're trying to flip those people as well. So they did this now to make a statement, but they're still investigating.
Yeah, and to your point,
Eamon, could I ask a quick question of Dan? Because on this point, I personally don't quite understand why the DA's office would charge the company now as the first of successive indictments. In my experience, the company would be the last thing charged at the tail end of an investigation, because obviously the company is not going to cooperate in any meaningful way. What would be the reason, since you were in that office, why the DA would charge the company partially now and potentially more later? Why not just hold everything until the end?
Well, I think your experience is probably similar to mine, that I had in federal court, which is that many companies are waiting till the very end and negotiating with the government in the hopes of getting out of a charge. I don't think that the Trump Organization, particularly looking at this indictment, had a particularly good argument. I mean, the office is required to follow a series of factors in deciding whether to charge corporations. This was not a company that could seriously argue that they had cooperated or that the wrongdoing wasn't pervasive or they had self-reported. I mean, the factors didn't really work for them. Obviously, we don't know yet about collateral consequences, as you and I have discussed, but they had the charge now. They're required to consider it under the policy, and there wasn't a realistic chance that the company was going to persuade them not to go forward. So they're going forward now, and then there may be additional charges they can bring down the road. That's the best I can tell you. Obviously, I wasn't in the room, so we don't know exactly.